Wyoming is often recognized or talked about as being one of the premier trust jurisdictions in the United States. People from all throughout the country, people from abroad, they establish trust in Wyoming because of this perceived idea that it is a top jurisdiction for trust, privacy, tax laws in the US. Today, I'm going to debunk 3 myths related to Wyoming and tell you why it's not a top trust jurisdiction. So let's get into it. All right, Wyoming is not a top trust jurisdiction in the United States. It is probably better than a lot of states in the US, but it's certainly not in the top 5, maybe around that top 10 spot, just depends. So today I want to talk about 3 myths and debunk those. The first one being that Wyoming is a premier asset protection trust jurisdiction. It's not. So there's a few different reasons that drive this. One being what we call the statute of limitations related to fraudulent conveyance of assets to a domestic asset protection trust. So that was a mouthful. What does that really mean? It means that where asset protection trusts fail are related to the assignment of assets. So the idea is that you cannot defraud a creditor. You can't just knowingly circumvent, intentionally circumvent an existing creditor or a creditor that is about to exist. So if you just all of a sudden impoverish yourself because you move all of your assets, the law says you cannot do that. South Dakota has a 2-year statute of limitations. So you can look back 2 years to see if any of these assets are intentionally circumventing or defrauding a creditor, whereas Wyoming has a 4-year statute of limitations. So it's actually double of what South Dakota is. I compare it to South Dakota because, as you know, I love South Dakota trust planning, and South Dakota is the premier trust jurisdiction. So South Dakota has 2 years. That is almost the shortest amount of time. I will say Ohio does have the shortest amount of time for the statute of limitations. It's 18 months. But other than that, Ohio is the only state that has it at 18 months. There's a few other states that have it at 2 years, but not nearly as flexible as South Dakota. So Wyoming fails when it comes to this. Another aspect is that every time you transfer assets to your domestic asset protection trust in Wyoming, you have to complete an affidavit of solvency saying that you're not basically impoverishing yourself, making yourself insolvent by moving these assets to this trust. So every time you do that, you have to go through this administrative process and fill out this required paperwork. Whereas in South Dakota, you don't have to. There is no ongoing continuing requirement every time you move an asset to this trust to fill out an affidavit of solvency. So when it comes to the statute of limitations and the affidavit of solvency, Wyoming just falls really, really short compared to South Dakota and other states. All right, so that was number 1. Number 2 is Wyoming doesn't have true dynasty trust planning. So as a reminder, dynasty trust is being able to put assets in an irrevocable trust, and those assets, that trust exists forever. Those assets can stay in that trust forever. Historically, there's been laws, the rule against perpetuities, that states that a trust can only exist for a certain amount of life, a certain lifetime, a certain amount of years. Once the assets have to be kicked out, then they're going to become subject to estate tax, potentially state income tax, depending on where you're located, as well as generation skipping tax. So if you can get all those assets into a trust, into a dynasty trust that exists forever, then those assets are going to be shielded from different types of taxes, particularly the wealth transfer taxes. Wyoming allows a trust to exist for 1,000 years. That is a really, really long time. In fact, it probably works in most people's heads as, hey, this is a solution. However, if you're going to the trouble to set up a trust in another jurisdiction, let's just say you're located in California or Texas or Florida or wherever it may be, and if you are going through the process of shopping around trying to figure out which state has the best trust laws for you, you're not just going to settle for one that has mediocre laws. So again, Wyoming doesn't have a true dynasty trust. It offers 1,000 years, but after 1,000 years, those assets are going to have to be kicked out. And at that point, they've probably appreciated significantly. And then they're going to have to, whoever the beneficiaries are at that point, are going to have to do additional planning. Whereas in South Dakota, it exists forever. You're not going to have to worry about that. All right, so that was number 2. That was Dynasty Trust. Number 3, we're going to hit upon flexibility. All right, so there are certain circumstances where a trust protector can amend the distribution provisions of a trust. They can change them depending on what's going on. They can add new beneficiaries. They can accelerate a beneficiary's benefit under the trust, whatever it may be. All right. South Dakota has very specific laws that give guidance on when you can do this. You know exactly what you can do. You know exactly what you cannot do. You know what you could potentially be liable for as the trust protector, what you're not going to be liable for, because it's all very well defined. In Wyoming, it is, for lack of better words, the Wild West. Their statutes are completely silent on some of these things. You don't know how it's going to play out. So not only is there no law there, there's going to be, I should say, obscure case law. There isn't even really an infrastructure in place that would be able to guide case law. So you're really leaving it up to the judge's discretion on what he or she is going to decide on whether or not something was allowed. Most people don't want to do that. I personally would not want to do that. All right, and then the next thing related to this flexibility is when you can decant assets. So decanting, as a reminder, is when you can assign assets from one trust to another trust. So you get assets in an original trust, and then you're going to assign them over to maybe it's a brand new trust, or maybe it's a trust that's already been in existence for some time. But the idea there is the first trust no longer works for whatever reason, and we need to move assets over to the second trust because the second trust is relevant. Maybe it's more in tune with current family dynamic or with tax laws, again, whatever it may be. There is very little guidance on when you can assign or decant assets in Wyoming to that second trust. And the statutes that are there are very limiting when you can actually do it. So they are really putting some handcuffs on you when it comes to that flexibility that you might need. Whereas in South Dakota has by far the most flexible decanting laws in the United States of any state that allows you to be able to move those assets from the first trust to the second trust without exposing yourself to any type of legal liability or being or really triggering some kind of unfavorable tax consequence or something like that. So anyway, Wyoming is not the best asset protection trust jurisdiction. It does not have true dynasty trust planning, and it really lacks flexibility.